of Lagos State, versus Attorney General of the Federation, which is reported in 2020, 12 NWLR, part 1738, page 203 at 236, where Rosevival GSC said virtual court sittings are not unconstitutional. That appears to be the main authority now today on the virtual court hearings. Now, in respect of criminal matters, this has now been statutorily provided for in Lagos State. But I still keep asking myself the question, if virtual court sittings are not unconstitutional, are they constitutional? I expected His Lordship to come out openly and say they are constitutional, but he said they are not unconstitutional. But does that make them constitutional, given the number of decisions they've taken in the past, which has defined public hearing? That is a question that may come up sometime later. Now, trials. Okay, courts are empowered to discharge defendants for lack of diligent prosecution and so on and so forth. Magistrates are to visit. These are things that have been there in the past but just improved upon. Where the launch of criminal data register known as the Lagos State Criminal Information System, I've already touched on records which the law enforcement agencies are entitled to keep. The offenses relating to indecent treatment of children or defilement, rape, and the rest of them may not be heard in the open court, while the courts have always used their discretion in that regards in the past. But while the same issue of definition of what public hearing amounts to. Now, restriction on disclosure of identity of victims and witnesses in any publication, and designation of names of witnesses with a combination of alphabets, just like is done mainly in the election petition matters. Now, you don't need to disclose the name of a witness. In recent case of Evans, I think, in Lagos State, some of the witnesses were said not to be willing to come to court to testify because of the fact that the last witness that testified received a lot of threats. And as a result of that, it's now very important for the witnesses to be shielded from the criminals or from the suspects. Okay, so that is the highlight of the Administration of Criminal Justice Law of Lagos State. Now, we also have the Petroleum and Industry Act, which was passed into law on the 16th of August 2021. Key areas touching on criminal justice system include Nigerian Upstream Petroleum Regulatory Commission, Nigerian Midstream and Downstream Regulation Authority, and then Petroleum Industry Fiscal Framework. Now, we have highlighted, you can go to the next slide, we have highlighted most of the contents of those laws as it relates to criminal indictment. So it is important to note that although they are simply laws to govern petroleum industry, they have criminal implications. All right. Now, the most important thing I would like to highlight there is in respect of the area of the hydrocarbon tax. There is now a provision, that is a fiscal framework.
Very happy to be
go to the slide of fiscal framework.
We get this project.
Yes. Now there is now a provision that directs the institution or imposition of the hydrocarbon tax
go straight to the
and that hydrocarbon tax, if you do not make certain declarations, there are huge fines that come with it, some of which are administrative penalties, and then others for which you are going to be tried. So I think it is important to remember this aspect of the provision, where they will come to litigation sooner than later, because Nigeria is getting more and more under cash crunch, and the effect of that is that government will look everywhere to make money wherever it can find it. Now, having said that, I think we can actually move on to the. We did a lot on the fiscal framework, but I'm sure that you go through your slides and go through the paper and be able to see that. But let me not end without reflecting on the gas flaring, which is the last slide on the fiscal frame. Yes, the gas flaring by licensee or lessee or marginal field operator, except in cases of emergency or pursuant to exceptions granted by the Commission, constitutes an offense under the Act and is liable to a fine as prescribed by the Commission in the regulations under the Act. Now, some of us may not know the effect of gas flaring and its problem in the society, but where you live in environments of the Niger Delta, you will understand exactly what the problem is. It is a very huge problem. Some people live constantly under the light of gas being flared, under the heat of gas being flared. Their farms and all that are affected, and of course, you know, the soot problem and so on and so forth. So many issues are involved. But Nigeria has been making money out of it and has not really bothered so much to address the issue. We hope that with provisions such as this, the issue will eventually be addressed, even though this one doesn't go to any extent in the real sense of addressing the problem. Now we move on to the Bank and Other Financial Institutions Act of 2020, which was enacted on the 13th of November 2020. Criminal sanctions imposed in the old BOFIA, that is Bank and Other Financial Institutions Act, have been retained and carried over, but penalties have been increased. So that is the major thing there. For instance, penalty in respect of the prohibition of persons other than a bank from issuing advertisement inviting the public to deposit money has now increased from a fine of 100,000 naira to a fine of not less than 50 million naira. This is section 44 of the new act. Now that is something huge, but considering the kind of problems that are being faced in society today, where so many people are collecting money from others, and when it is time to pay back, they disappear. I think this is quite a step in the right direction. Now, under the BOFIA, any bank advertisement which fails to comply with extant regulations is liable to 50,000 naira and an additional fine of 1,000. That is the old BOFIA, 1,000 for every day. But this time around, there is an improvement. It is now going to be a fine of 5 million naira and additional of 100,000 every day. Now there is also penalty for the prohibition of receipts of commission by staff and officers of banks, which has now been increased from 50,000 naira to 5 million naira. So these are some of the provisions that are highlighted in respect of the POFIA Act. Now we go to the anti-open grazing laws of southern states of Nigeria. We all have read so much about open grazing and the problem it has caused in our society, almost separating brothers from each other. The southern states appear to be more keen on addressing the issue by making certain specific provisions. And here we have now Abia, Bayelsa, Ebonyi, Ekiti, Oyo, Rivers, Ondo, Enugu, Akwa Ibom, Osun, Delta, and Lagos State. We have identified their laws for you in the paper. They have all enacted their own laws banning open grazing in their territories. Now, for Ekiti, it is an offense for any person to graze any land that has not been designated as a ranch, and any person who contravenes the law commits an offense and is liable to conviction to imprisonment for a period not less than 6 months without an option of fine. Now, that of, I think, River State, he said offenses under River State law include prohibition of livestock on foot, prohibition of possession of firearms, prohibition of land grabbing, prohibition of animal rustling, prohibition of ranching without approval, prohibition of ranching without a permit, and prohibition of sale of land for ranching. Now, in respect of River State, theirs is open rearing and grazing. It's just different from the ordinary open grazing. But open rearing and grazing, that is what they have decided to criminalize. But when you look at the items, you may find that there would be one or two items there that may be subjected to litigation sooner than later. For instance, prohibition of firearms, bearing of firearms. Now, is that a matter within the constitutional rights of a state? Now, we feel that in spite of the efforts that have been made, the issue as to enforcement also remains an issue that cannot be ignored. The states have the right to make laws with regards to criminal offenses. But do they also have the right to enforce those laws? Apart from Attorney General charging a person to court, which is entitled to do in a state court, who acts as the police to bring that person to book in the first instance? So that is still a big problem, because the police is under the control of the federal government, but the power to make laws as it relates to criminal matters is vested in the state government. In other words, at the end of the day, except the two parties agree to support one another and work with cooperation, there is every likelihood that most of the laws being made will not be easily enforced. We are already seeing that. Abia State has made its law a long time ago, but up till now, you still pass through the roads in Abia State and you find cars cattle grazing openly. So is it that the state government is not ready to enforce its own laws? or is it that it's not receiving the cooperation of the federal government to enforce those laws? So these are some of the issues that will be thrown up with these laws that are being made. Now we now move on to the Lagos State Public Complaints and Anti-Corruption Commission Law 2021. Now, Lagos State has a way of being at the forefront of legal development in this country. We cannot deny that. But this time around, they were beaten to it by Kano State. It was Kano State who first made the law of this nature. Lagos State has now made its own, and it was enacted into law on the 19th of April 2021. It established Lagos State Public Complaints and Anti-Corruption Commission, which is responsible for the administration of the law as it relates to investigation and prosecution of allegations of financial crimes. And note this, allegations of financial crimes and corrupt practices in Lagos State, especially where the finances and assets of the Lagos State government are affected. The commission has the power to investigate under the criminal law of the state relating to corruption, and then also abuse of office, offenses relating to administration of justice, obtaining by false pretenses, among others. Of course, these are crimes under the Lagos State law and under almost every state's law. That the commission is empowered to take over the investigation of anti-corruption and financial commission cases involving the finances and assets of Lagos State government being investigated by any other agency. That obviously includes EFCC. The commission is prohibited from investigating any matter that is before or that is pending before a court of law. That is the only limit to their powers. Big question. Is that constitutional? If not, why not? Because the debate will continue. The Attorney General of Ondo State against Attorney General of Federation, which pronounced on the powers of the federal government to establish the ICPC, appeared to have given the go-ahead for the federal government to intervene in such matters. Is that good law? Is there a problem with it? I think a body like this might be able to come up with a resolution of that matter. I have my personal views. I thought that the Supreme Court went too far. Because if that law or if that their pronouncement is enforced to the letter, state governments will be no more than ordinary agencies in the hands of a federal government. Now, the states have their powers deriving directly from the Constitution, which includes the powers to investigate the issue of corruption, which is vested in the State House of Assembly under Section 128 of the Constitution. But the federal government apparently trying to bridge the gap that existed at the time, or that they perceived existed at the time, decided to rely on Chapter 2 mainly to come to the conclusion that the federal government is entitled to make those laws. Now, it will be a matter of discourse whether or not the approach we are taking to interpretation when we are talking about covering the field is actually the correct approach. Because we have a situation where powers are vested in the state government to make certain laws, and at the same time vested in the federal government to make similar laws. And then the state government makes its own laws as it relates to the state. And then it is supposed to give way to that made by the federal government because, in quotes, the federal government has already covered the field. That is an issue that you will find when there are a few litigations pending in court now in respect of the Freedom of Information Act. I personally hold the view that the Freedom of Information Act cannot be applied to states, because when you read that Freedom of Information Act, you are going to discover that if it is applied to states, then the state governments will be reporting to the Attorney General of the Federation, which is absolutely out of place and not in line with the federalism that we say we are practicing in Nigeria. So these are some of the issues that may arise with regards to the Lagos State Public Complaints and Anti-Corruption Commission law. Well, I have identified some of the things that the law prohibits and then the punishment that goes with it. We spent about a few slides there. I'm sure that you'll be able to deal with it. Now, I'll move on to value-added tax of laws of Rivers and Lagos State. Well, the landmark decision that has ruffled feeders in Nigeria more than anything in recent times is the decision of the Federal High Court in Port Harcourt in the case of Rivers State versus FIRS and another. Rivers State government went to court and got an order to the effect that it is the one entitled to enact the federal, value-added tax laws for Rivers area and not the federal government, and that it is the one entitled to collect such taxes. As a result of that, the Rivers State government made its own laws, which was enacted on the 15th of August 2021. Under it, taxable persons are within 6 months to register with the board of, with the Internal Revenue Board for the purpose of payment of value-added tax. Failure to do so constitutes an offense which is punishable with 50,000 naira or 100,000 every month after you fail to register. So that is the criminal aspect of that. Then there is also the provision to the effect that it's an offense to furnish false documents and so on and so forth. The usual provisions you will normally find in tax laws. Now, the debate is still ongoing as to whether or not that judgment is in line with the law. But that is a matter that is now sub judice, and I'm not free to comment on it. But what is important to note there is that if the value-added tax law of Rivers State and Lagos State are upheld, there are criminal implications for anybody to fail to register or to fail to pay those, make returns in respect of the value-added tax. I started the matter It was my case, my personal case, where the first judgment was given to the effect that the federal government has no power to legislate on value added tax, for the good reason that it is not contained in any of the items of legislation under the exclusive legislative list, nor is it contained in their favor in the concurrent legislative list. Now, the FIRS, on becoming aware, because they were a party to my suit, that judgment had been given against them, caused a letter to be written to the National Assembly to say, please include value added tax in the exclusive legislative list in the amendment of the Constitution that you are trying to do. Now, that has not yet been included. Meanwhile, the case of Rivers State government was still pending in court, and the judge followed the same decision that the Federal High Court had earlier given, and came to the conclusion that the federal government has no powers to impose value added tax. Well, whether they are right or wrong is left for the court to decide. Now I go on to part B, because I know my chairman is not a very friendly person to me. So, now, under part B, which is judicial review, we have a number of cases that have actually been highlighted for us by the organizers of this, conference or seminar. Now, the first of which is Amuda versus FRN. Thank you, sir. Thank you, sir. Now, prior to this decision, it was the established position is that if you sign notice of appeal on behalf of your client in a criminal appeal, that notice of appeal is deemed to be invalid and will be set aside by the court. We have drawn attention to a number of cases in this regard, most of them decisions of the Supreme Court. Now, but this time around, the Supreme Court has come to the conclusion that there is a proviso which gives the court a leeway, such as to allow some form of discretion to be exercised with regards to the notice of appeal in a criminal matter signed by the counsel and not by the appellant himself. We have analyzed the position to the best of our ability, but what we need to say, and this is my own humble advice, is that in order to be safe, you are still better off getting the appellant to sign the notice of appeal where the appellant is available. You are still better off getting the appellant to sign the notice of appeal. That is simply because even the form does not have provision for signature of counsel. It only has provision for signature of appellant. So I think that it's still safer, because we never know. A panel can come up tomorrow at the same Supreme Court and take a different view. So to be on the safe side, my simple advice is get the appellant to sign by himself. Now we have the case of Woguche versus FRN. In that case, in line with the decisions such as Benjamin versus the state and the rest of them, the Supreme Court drew a distinction between a court raising an issue suo motu and a court suo motu relying on authorities and statutes not cited by the parties, but which are applicable to the facts of the case. Sometimes the distinction can be quite a tight one, very difficult sometimes to draw. So you see so many people drawing up grounds of appeal and talking about the court having entered into the arena to nominate issues to decide. But what this decision is trying to highlight is that there is a distinction between raising an issue suo motu and or suo motu relying on authorities. A court or a judge should not be constrained to follow the wrong decision cited to him. If, for instance, you cited a decision, as we have seen in the past, where people have cited decisions that are minority opinion, especially with the use of the legal law pavilion, where most of us cannot see. I don't know about you, I'm an old man, so most of us cannot go through the entire distance. So you just see something highlighted, and then you say, yes, that's what I'm looking for. Not knowing that what you're citing is actually the minority view of a judge amongst a panel of judges. So when you go and cite that to a judge, is the judge bound to stick with it or to hide from the fact that this, in fact, being a minority decision, I'm aware that there are decisions which are opposed to this particular position. And then he goes ahead to cite those decisions. When he cites those decisions, it's like he's suo motu citing authorities, which was not drawn to the attention of the parties. Indeed, you can argue that if he had drawn your attention to it, maybe you would have drawn a further distinction. But the court is saying, no, once that is done, the judge is doing so within his rights, that he is not bound to simply stick with the few cases or no cases you have cited. He can cite his own cases to support the position he's taking in his judgment. That on its own does not amount to raising issues suo motu. We have the case of Uche versus FRN, which so the fact that the Court of Appeal relied on Section 122(2) of the Evidence Act regarding matters which a court may take judicial notice of, and Section 168 of the Evidence Act on presumption of regularity, to hold that when the lower court directs or orders, when the lower court orders or directs that a charge be read, that it is presumed that it is the registrar or the officer of court that reads the charge and not the prosecutor. Well, that is the decision. What your views are, we probably will hear from you later. We move on to the case of Yame versus FRN. The Supreme Court held that Section 36(12) of the Constitution of Federal Republic of Nigeria does not provide that the definition and penalty sections must be stated. Well, we find some people making that very serious technical issue, very serious technical issue, that he did not state this, he did not state that, but the court is telling us we really don't need to get to that extent. So it is held that it is immaterial if conviction is under a wrong section or even if an entirely wrong law. Once the facts leading to the conviction constitutes an infraction provided for by a written law, the appellate court will not interfere with the conviction. Well, whether you agree or not, that is the position of the law as pronounced by the Supreme Court now. Now, Mohammed versus Attorney General of the Federation, the Supreme Court held that the three ingredients of the offense of trafficking must be established, and they have identified those three ingredients before one can have a conviction. The interesting thing about that case is that the appellant who appealed was initially sentenced to 3 years imprisonment, yes. Was sentenced to 3 years imprisonment. But at the Supreme Court now said no. The court has no discretion. When a provision has stated the number of years of imprisonment to be imposed, the court cannot exercise its discretion to lower it. So they improved on the decision of the lower court and gave the appellant 10 years. So he was complaining about 3 years. He ended up with 10 years. Now, generally, the danger that is involved in appealing against sentence is known to experienced lawyers. So, an experienced lawyer will not draft a notice of appeal and appeal against the sentence. Rather, you appeal against the conviction. Now, when you appeal against the conviction, you are safe to maintain the sentence. But when you appeal against the sentence, you throw yourself open. At the end of the day, you can have a visitation such as this. But in this particular case, it was not even that the appeal was against the sentence. But rather, he was appealing on some grounds. And then the Supreme Court looked at it and said, look, where did the High Court or the court get the power to impose a sentence that is lower than what is prescribed by statute? So they then gave him 10 years instead of 3 years. So I think that is a point worthy of note. Now, the case of State versus Ali, the Court of Appeal held that the Judicial Officers and Appeals Prosecutors Act number 10 of 1963 is extant, and there is until there is an express repeal of the law, or the Supreme Court overrules it in another decision. Now, the decision has reaffirmed, and this is important, the fact that an appeal against a capital offense must be filed within 7 days. Otherwise, time cannot be extended. This portends very grave danger. But that is the position. Now, the state against Chuang, which is essentially the decision is to the effect that time consideration retrospective and not prospective. The court also held that in considering the grant of bail, it is the affidavits and not the proof of evidence that should be relied upon. In other words, in an application for bail, it is the affidavit evidence before it that a court should dwell on rather than the proof of evidence. Yes. Now, my concern here is I thought that the proof of evidence is what actually provides the basic material upon which the court can come to a conclusion as to whether there is a case sufficiently important or sufficiently weighty for an accused person to be detained until the trial is taken. I thought that the proof of evidence is very material. But here they said it's affidavit. Now, we have dealt with the issue of Balogun versus FIRN. The case of Balogun versus FIRN. We have dealt with the issue of Datsuki versus FIRN, particularly in respect of Datsuki versus FIRN, to the effect that, as Abiola would say, you cannot shave a man's head behind his back. He has to be present for you to be able to cut his hair. You cannot make findings that will render a person liable, criminally liable, for an offense for which he has not yet stood trial. So that's a very important one. So on the whole, we have seen that our criminal justice system has been deeply enriched by recent legislative innovations. The innovations of particularly relate to state government deepening the practice of federalism. I know that most of these will eventually end up in the courtroom. The need for continuous fine-tuning of our criminal laws cannot be overemphasized. It's always there. The judiciary remains alive in its vital role of ensuring peace, order, and good governance in our society. Individual and collective efforts are required to ensure that we have a robust and resilient criminal justice system. I thank you very much for tolerating me.
Yes, JB is not happy we are backslapping. Well, JB, you can't do much about that. I think Ukalaisen deserves a better hand than what we gave. We are always told that the taste of the pudding is in the eating. When I was trying to describe him before he started his presentation, you might think I was putting him in a borrowed robe. But the presentation has shown clearly, when I said he's a very deep person, quite incisive. I took copious notes during the presentation, but I have this attitude for two reasons why I don't summarize people's presentations. One, you do injustice. No matter how good you are in précis, you may not be able to catch the essence and the kernel of the presentation. So I avoid doing that. But importantly, those who come late for events must lose something. When you now do the paraphrase for them, what they missed, but it was not meant for you, but you came late. I saw you. So when that happens, you are rewarding lateness. So that's why when I'm chairman and I won't paraphrase, I won't tell you the summary. You should be asking people you met what had happened before I came in. That is the price you pay for coming late. So for those two reasons, I don't summarize lectures. But I have my notes for keeps. I must say that, and luckily, towards the tail end of the presentation, one of the discussants sneaked in. Jibril Okute, Personal Advocate of Nigeria. For those who are courtroom lawyers, when you fix events for between 9 and 12, you run a mighty risk that they will be in the court doing what they know best to do. I remember I was with Jibril yesterday in the Supreme Court, and I left him there for obvious reasons. So I won't be surprised that he has gone to do some other battle with some other people today. That being as it is, I think for him to settle down, because I want him to catch his breath properly, I'll call Dr. Femi Afolayan to come and take the podium and do his own 10 minutes presentation. Then Okutepa SCN. Is he on? DC, are you still negotiating the checkpoints between Owerri and wherever? It's on. It's not. So I will then call on Femi Afolayan, Dr. Femi Afolayan, to please come, take his 10 minutes. By that time, Okutepa SN will have been properly settled in to do his own. Ground rule, 10 minutes. I told you at the beginning, I know this DC will not make this connection. So, Ukala SN chopped his time and chopped DC's time. But you don't have another time to chop apart from your own. So, and I think I have more control over some people. EC is still the chairman of LPDC. I don't want to be dragged before that body for professional misconduct if I was too hard on him. So I've put water on the ground though. Even in spite of this, please come on, Dr. Fola here. Thank you.
Permit me to thank the founder of the Rule of Law Development Foundation for considering me fit to be a presenter in this August gathering. I also want to appreciate the chairman, my mentor, for being the chairman of this occasion, and my Lord and all senior colleagues and other colleagues here present. The topic given is judicial updates and legislative development in criminal procedure law 2021. I was given only 2 days notice to do this presentation. So, and I will act within the time frame given. This paper focuses mainly on recent developments introduced by the legislatures and courts as it relates to administration of criminal justice law in the last 1 year. Legislative updates. As at October 2021, only 5 states in the northern parts of Nigeria have not adopted administration of criminal justice law, ACJL, as state laws. These states are Kebbi State, Zamfara State, Niger State, Taraba State, and Borno State. All other states in Nigeria, including the Federal Capital Territory, have adopted the administration of criminal justice law at state level and Administration of Criminal Justice Act at federal level. This is an encouraging development in the process of harmonization of criminal procedural laws and making moves to reduce delays and increase efficiency and effectiveness of the criminal justice system in Nigeria. The administration of criminal justice law was introduced in Lagos in the year 2007. That's the ACJL Lagos. The law was repealed and reenacted in 2011 and further repealed and reenacted in September 2021. The 2021 repealed and reenacted law introduced some innovations which had been highlighted by the chairman, by the lead presenter, like conducting proceedings through audio and video conferencing. Chief magistrates were given powers to visit police stations at least once in a month. Then prohibition of media parades of suspects. The law prohibited media parades of suspects. Then provision of compensation and protection for victims of crime and witnesses. Then provision for the establishment of crime data register, and provision for the establishment of criminal justice sector reform committee
to monitor the implementation of the law. Judicial updates. The Court of Appeal Rules 2021 came into force on the 1st of November 2021. So the commencement date is 1st November 2021. That's going by Order 1, Rule 1 of the Court of Appeal Rules 2021. And the following innovations were introduced in the rules. Every notice of motion shall be accompanied by a written address of not more than 5 pages, Order 6, Rule 1. Then the response to the motion, to the notice of motion, which must not be more than 3 pages, shall be filed within 5 days of service, and the reply, if any, on points of law, shall be filed within 3 days, Order 5, Rule 1. The time within which to do certain things shall stop to run whenever there is occurrence of events that disrupts the normal business of the court. Order 19, Rule 12. For instance, where judiciary staff, when they go on strike, time within which to file processes will not run for that period. Then electronic filing is introduced under the rules. See Order 20 of the rules. Then virtual hearing is also introduced under Order 21 of the rules. There is also electronic compilation and transmission of record of appeal, in the addition to the physical compilation and transmission. On this, please see Order 8 of the Court of Appeal rules. Then we also have electronic service of record of appeal, in addition to the physical service is provided for in Order 8 of the rules. Under the new rules, there is also provision for deposit of at least 50,000 naira by the appellant as security for cost and to ensure diligent prosecution. See Order 8, Rule 11. There is no deposit is required for indigent persons or from government. So if it is a government department or government agency that is filing, there will be no need to pay security for cost. And also indigent appellants. Appeal may be withdrawn by consent of parties without the need for an order of court. All that is needed is filing of the documents signifying intent to withdraw. See Order 11 of the rules. Then we also have daily default fee of 200 naira for failure to file brief. Is provided in the third schedule to the rules. Appeal shall be struck out where there is failure to compile and transmit records. It may be relisted upon application within 7 days where good cause is shown. See Order 8, Rule 18. Notice of appeal may be served physically or by electronic email to the respondent. Order 2, Rule 1. The sittings of courts and matters to be disposed of shall be notified to parties by physical or electronic email. Cases, that's judicial decisions. On the electronic recording of confessional statement of suspects or taking such statements in the presence of a legal practitioner of the suspect as contained in Section 9.3 ACJL Lagos, that's 2011, and Section 15.4 and 17.2 of ACJA 2015. And the cases of Fatoke against people of Lagos, Zia against people of Lagos, and Unajio 4 against FRA. The courts in this case is held that these provisions are mandatory and must be complied with by the police or law enforcement agents taking and recording the conventional statements, and that non-compliance will make the statement inadmissible. However, in the case of Ajiboye against FRN, that's Supreme Court, Sanusi GSC held as follows, and I quote, on the alleged absence of his counsel when it was recorded, I think that the reason is not cogent, as it is not incumbent upon the prosecution to record an accused statement only in the presence of his defense counsel. The important and essential thing is that words of caution must be administered to the accused person, to his understanding, and to endorse same before he decides to make his statement. Also, in the case of Ugo Allah against the state of Lagos, the Court of Appeal held that Section 9.3 of ACJL Lagos, a law enacted by the House of Assembly of Lagos State, cannot govern admissibility of evidence in criminal proceedings, since evidence is listed as item 23 in the exclusive legislative list in the second schedule to the Constitution of the Federal Republic of Nigeria, as amended. Thus, the Lagos State House of Assembly cannot validly legislate on matters that are within the exclusive legislative list of the Constitution. See also the case of Benjamin against Kaleo, Sunday Okundo against the people of Lagos, where it was held that confessional statement of the accused, where he admitted to have robbed a student of 20,000 naira, which confession was not electronically recorded nor attested to by a legal practitioner, was admissible and sufficient to convict him of the offense of armed robbery. It will appear, therefore, that notwithstanding the laudable provisions of Section 9.3 ACJL Lagos and Section 15.4 and 17.2 of ACJA 2015, the requirement for video recording of confessional statements at the police station or the recording of such statements in the presence of the accused legal practitioner cannot be the basis for admissibility of evidence, as only the Evidence Act 2011 and the Judges Rule regulates admissibility of evidence. Conclusion. In 2020, as I have said earlier, only Imo State and Yobe State, in 2020, only Imo State and Yobe State passed their ACJL into law. The only state that passed ACJL into law in 2021 is Gombe State. We urge the remaining states yet to pass the law, that's the 5 states, to adopt and pass the ACJL as their law. There is no doubt that the administration of criminal justice law is progressing in Nigeria, particularly with the repeal and reenactment of the ACJL Lagos 2021 and the introduction of the Court of Appeal Rules 2021. Thank you for listening. Mr. Chairman, I hope I have not exceeded my time.
Thank you very much. I think we can do better. Dr. Femi Afolana, thank you very much for the perspective you have brought on the discourse. Bruno Kutepa SAN is a man known very well in the circuits of courtroom lawyers. And one thing that you can be very sure about him, what you see is what you get. May I now invite Bruno Kutepa SAN to come and have his own 10 minutes bite in this discourse. And after, we are going to turn this over to the members of the audience. So go and follow the part that you think will be easy. Nobody tells mahoganies to move. Which one do you know about? The adumbration should not be longer than the brief.
this is a serious matter. Well, first of all, let me apologize for coming late. And I'm happy that my elder brother, who was with me yesterday and who left me behind, has clearly told the audience the reason why I came late. So I apologize. Secondly, I want to thank my president, the Chief J.B. Daudu, Esquire, SAN, who deemed it fit to invite me to be a discussant of a paper that I didn't see until I came here. So, my apology number 2 is that I have no written presentation because I didn't see what I was coming here to discuss. So I couldn't have prepared to discuss what I didn't see. And because I know that I can't preempt Chief Isiukala SAN, my Oga, my Egbon, and whom I know well, it will be difficult for me to be able to discuss his paper or that of Chief DC Denwigwe. But be that as it may, one of the controversial cases that I found at page 80, which he discussed and which had been agitating my mind, is the case of Dasuki versus Federal Republic of Nigeria. And I think that while we have commendations for our judiciary, we also need to be a little bit careful in order not to lay a landmine that may at the end of the day be used as part of the instrument to emasculate and castrate one of the arms of government in terms of materials of prosecution. And I speak about the case of Dasuki versus Federal Republic of Nigeria. We all know the facts. Dasuki was not an accused person before the court. It was nevertheless, in the judgment, certain strictures were cast at him, and he went on appeal to the Court of Appeal, and there was a challenge to his locus to file that appeal, being not an accused person and being not a person that was convicted. And if you look at order 17 of the then Court of Appeal rule that gives right of appeal and all of that, you will know who has the right of appeal. Section 243 of the Constitution also talks about who has the right of appeal. Now, the Dasuki's case is contrary to 2 decisions of the Court of Appeal on the same point as to whether or not a person who was not an accused person can file an appeal in a criminal matter. And indeed, as to whether or not a person who is not an accused person and who did not stand trial can appeal as an interested party. And the Supreme Court, in the case of PACS versus Pass Education Resources Limited versus Federal Republic of Nigeria, 2020 Law Pavilion Electronic Report -51181 Court of Appeal, at page 17 to page 24, was emphatic on the point that you cannot even bring an application to appeal as an interested party. Second case is a case of Panasonic Industry Limited versus Attorney General of Bayelsa State, 2018 Law Pavilion Electronic Law Report. And You can find it at page 9 to 13. The point I'm struggling to make is that while it is good and it is a principles of universal acceptability that you cannot shave somebody's head behind his back, the process of ventilating your grievances must also be provided in our laws. My submission, therefore, is that looking at the innovations that were gathered here this morning to look at, to comment on, and to either approve or commend either the enactment of laws or the judicial pronouncement, I think that for those of us who are courtroom lawyers, when the right of appeal is statutory, it's constitutional, it is statutory, and so when you look at the Court of Appeal rules, either as currently amended, the new one, or the old one, or our constitution, it appears to me that the draftsmen of our laws have not yet created a right of appeal against persons who were not accused persons in criminal trials. But the Dasuki's case was decided on the basis of fundamental right. And again, with respect, I criticize that judgment because when your right to fair hearing has been breached, the provisions of our Constitution, Section 46, talks about that you should go to either state high court or federal high court to enforce your right. So the Court of Appeal is not an original, court for where you can go to enforce your fundamental right by way of notice of appeal. Therefore, my submission this morning is that that judgment stands on its own, and it was decided without being guided by the previous decisions of the same Court of Appeal. Within the parameters of the conflict of decisions, therefore, is that we have two conflicting decisions of the Court of Appeal as at today, whether or not a person who was not an accused person has a right of appeal, and indeed without leave. And there are praetorias of judicial authorities that you cannot file an appeal even when you are directly affected and are not a party without the leave of court. And the Supreme Court had come down heavily that where leave is required and leave is not had and obtained, then you cannot appeal to the court. Therefore, I'm waiting to see what the Supreme Court will say about the Dasuki's case. And I criticize that judgment too on other front. Second criticism of that judgment is that if that judgment is allowed to stand, then the state will be completely castrated or prosecuting those who may have committed a crime and decide to take flight from the shore of this country. For instance, if somebody decides to siphon the money of the state and put it in my account, and it's traced to the person has run away, is now a fugitive, and I'm the only one available, and you are now saying until the state can find the person who put money in my account in corrupt means, then there can be no prosecution. So there are decisions of the Court of Appeal, Yusuf against the Supreme Court, Yusuf against Federal Republic of Nigeria, where the Supreme Court said that it is not unusual to charge a person with somebody at large, and that the person does not need to be physically charged with a co-conspirator before he can be convicted of conspiracy. After all, their lordship said, conspiracy can only be proved by circumstantial evidence, because you can hardly find two conspirators meeting in one place. So, my contribution this morning, before Malam Yusuf Ali will order me to sit down as he has always been doing, let me say that he did so to me yesterday in the Supreme Court. So, I'm used to him. And my submission this morning, therefore, is that the Dasuki's case should not be a a case that we should celebrate. Not on the basis of the fine principles of law that they are attempting to, I think my president was in the matter. Not on the basis of the fine principles of law that their lordships are trying to. But let us look at it tomorrow. We may not have good people in power today. But if by tomorrow we have good people in power, and some people have decided to milk our treasury dry and take flight and leave Austin and myself in Nigeria suffering the excruciating punishment that we are going through now, will we say that the state should not be able to prosecute those who are available within the law until the person who is a fugitive is brought before the court of law? What if they decide to renounce the citizenship and become citizens of another country? So, and more people will follow this pattern. In other words, in conclusion, I submit that in laying judicial precedents, the interest of the state must be paramount in our mind, because no judicial officers live in Ireland. We all live in Nigeria. And so whatever we need to do to ensure that the criminal justice administration in Nigeria is not starved of raw material, we must do so. But to lay a landmine in this kind of decisions will encourage Nigerians who have propensity for criminality. And in any case, we are all witnesses to what we see in our electoral jurisprudence, where it is difficult, if not impossible, to prove rigging. If their lordships could take judicial notice of rumors in construction sites, I don't think it is too difficult for them to also take judicial notice of the criminal tendencies and criminal enterprises of Nigeria, which is number one in the world, to see that we don't encourage more people to engage in criminal enterprise and flee from the shore of this country, because you and I will be a direct victim of those conduct. Thank you, Mr. President. Thank you, the chairman and the lead presenter. This is the little I can say from my head, and I thank you for giving me the privilege to air my view. Thank you, sir.
Let's encourage him more. Thank you very much. That is the beauty of advocacy. You wake up and advocate in the middle of the night. You can be very sure you will have something sensible to say about the issue at hand. Thank you very much. I'm happy to announce that this Idenigwe SCN has been found. Because as we are negotiating those labyrinths of the very dangerous roads between Owerri and wherever, my heart was with you. You are very precious. Your kidnap value is very high. You are former Attorney General of Imo State. This year, are you listening? We are only reading your lips, so unmute yourself now, DC.
Are you okay?
You are here now.
Thank you so much.
I said we thank God for life because your kidnap value is very high. So when I heard
I had to rush all the way from Port Harcourt.
Imagine. So you're welcome. Now, luckily for you, the next thing I was going to say actually, after the presentation of Okutepa, SCN, was that look, we'll help you to adopt your brief, which is at pages 87 to 116 of the bundle of documents. But you are lucky because, you know, it's allowed under the rules of the appellate courts.
Sorry, your voice is breaking.
Okay, that would be a problem. Okay, now you have 15 minutes, DC. 15 minutes. Can you hear that?
I had 15 minutes.
That's what you have.
Okay.
That's all you have.
Thank you.
That's the totality of what you have.
Thank you.
15 minutes because we have taken so much time because we started late. If we are not careful, people will not be able to make contributions as much as we want. And I see a lot of people who are hangling to take on the lead presenter and others. So, this is Denigwe, SAN, you're on your own. Start.
Thank you. I want to give thanks to God for the opportunity given to us once again, and I congratulate the Rule of Law Development Foundation for this outing. In view of the shortness of time, I'll simply run through a skirmish attention to the few decisions that I have drawn attention to. I'm happy that my learned brother Isiokala has already dealt with the issue of updates on legislations that touch on the subject matter. Now, the first attention I found it necessary to draw is to the issue of use of search warrants, which featured in the issue of the version of the House of the Residence of Supreme Court Justice. I have submitted that we need to be particularly careful in the handling of any process of court which affects the fundamental rights of citizens in any way at all, rather than what I would call the show of shame that has embarrassed the nation on that issue of invasion. Then I go straight to the issue of the treatment of the cases. I drew attention first to the number one case that attracted my interest. That's the case of Amuda against FRN. And I drew attention to the point that the Supreme Court was on the right path when they departed from the SY position that the appellant must sign his notice of appeal. Now, the decision opens the way to confirm the fundamental right of the citizen to representation either by himself or counsel of his own choice. So all the former decisions which limited that liberty of the citizen to take advantage of the provisions of Section 36, subsection 7 of the Constitution has now been put away. Then my next attention was to the case of the state against Yanga, where the issue of the absence of written address for the appellant was dealt with by the court. I agree with the position that the right to have the appellant's written address or the accused person's written address presented is a fulfillment of the fundamental rights to fair hearing. So the trial judge, to my mind, was wrong in proceeding to treat the case in the absence and without the opportunity of a written address for the appellant. Then in the next attention is to the case of Lucky Obasi against the state, where, because of shortness of time, I just want to draw attention to the portion of the decision of the Supreme Court where they said the right to fair hearing the appellant claim was denied him in the absence of the speedy trial was waived by him through his conduct and through his incessant absence from court, including those of his counsel and his co-accused. I'm of the opinion that there's a need to be particularly very careful about such pronouncement, because the Supreme Court had earlier held in Ariori against Elemo that the right to fair hearing cannot be waived So I think that what happened in this case is that the accused, the appellant, was demanding an unfair hearing instead of saying that he waived his right to fair hearing. I think it is safer to stay with the position that fair hearing, which touches on public policy, cannot be waived. Then in the case of Akachi against the state, we dealt with the issue of, I said very respectfully, the duty of the court in such situation must be to quash the charge once it is seen that there's no case for him to answer. To still maintain or retain the case on the cause list was wrong, because the longer the charge hangs on the neck of the appellant, it amounts to a denial of fair hearing. Then, in the case of the state against Chukwan, that was the case of the issue of bail. I think the learned trial judge went to the other extreme of exercise of discretion, which was rather on very flimsy reason. He set free accused persons in a capital offense, dealing with the issue of relying on the fact that the number of counsel who appear for the accused persons will likely delay the trial. There's no way such an exercise of discretion in such a manner can qualify as justice. Now, ordinarily, the right to bail is automatic in normal cases, but the Constitution itself made an exception in cases of capital offense, where the position is that the person who asks for bail should give the special reason warranting the exercise of that discretion in his favor, contrary to the other situation where, in an ordinary case, the person who opposes bail should give good reason why that should be so. Now, the next case is the case of Mohammed against the Federation, where the central issue was whether or not the trial court had any discretion to reduce sentence. My position there is that if the statute has limited the power of the court to reduce sentence, then that power doesn't exist. The court is there to apply the law and not to show sympathy. Sympathy is not a forerunner of justice. Now, the next case is the case of Dasuki against the FRN. Now, the appellant was not a party to the charge, and yet pronouncements which indicted him were made by the court. I think it is a gross violation of fundamental right to fair hearing. At least for one, the Constitution gave the right to the appellant to be present in his trial for any criminal offense. And any conclusion which amounts to finding him liable or guilty of a criminal offense in his absence is a violation of that right. Then the next is the case of Aminu Sadiq Obucha against FRN, where I said it is respectfully submitted that a finding of existence of a reasonable suspicion or likelihood of existence of a threat to national security should never be left to presumption on the mere exit of the prosecution. Fair hearing demands that some sort of inquiry should be made to discover whether it is true that there is a threat to national security. Now, the case of Dekwesi against FRN, the decision of the Court of Appeal in this case, most respectfully, at first instance, glance, appears to be a negation of the decision in Amuda against FRN. Now, because in the Amudan FRN, the Supreme Court had firmly confirmed the competence of a notice of appeal signed by the Appellant's Council. But this case, at the first sight, appeared to be sticking to the old decision. But a closer look at that decision shows that they actually confirmed the fact that the council can competently sign the notice of appeal. So the next case is the state against Abdullah Ali. We said this case states the law on time within which the prosecution may appeal against acquittal in a capital offense. Having heard that the judicial etc. officers have appealed by prosecution cap number 10 of 1963, which, though omitted from the laws of the Federation of Nigeria 1990, and 2004, that it was not actually repealed. So, in other words, the position of the law remains that a prosecution by the state must be commenced within the time stipulated by the law. Now, Abubakar Suleiman against FRN. This case has settled the issue of the power of the Chief Judge of the Federal High Court to transfer the criminal case to be tried in any other judicial division other than the judicial division where the event occurred. I think it's a welcome development because, as a matter of fact, the issue of availability of witnesses and all that should come into play in determining venue for a trial of a case. Then, in the case of Mbede against Nigerian Army, I said in this case, the Court of Appeal held that an accused person who complains that the charge or information is defective must show that the defect has deprived the court, tribunal or court martial of the jurisdiction to try the offense contained in the charge. Now, I think that is a proper statement of the law by the court. And once it is manifest that there's an error affecting the fundamental of the competence of the charge should be thrown away without any ado. Then, in the case of IGP against Matthew Sonoma, in this case, the Supreme Court held that the discharge of an accused person on the ground that the accused had no case to answer is tantamount to an acquittal. I think I agree that is a correct statement of the law. Then, Daniel Edet against FRN. The Court of Appeal held that by the provision of Section 2161 of the Administration of Criminal Justice Act, neither party to a criminal proceedings can on its own amend or alter the charge. I agree that any process of court that will be relied upon by the court to make a decision should be duly put before the court and leave sought, and all the parties each having equal opportunity of knowing what it is all about before the court can utilize it. Then only segment 2, where the Court of Appeal took time to explain the occasion and elements which constitute judicial bias. This case drew my attention to the story that we were told at the Nigerian Law School by no other than Baba Ibironke, the Director General himself. And as I read the decision in this court, I remember the details and in the venue of the classroom where that story was told. Concerning the trial of an accused person in a running down case who was defended by a lawyer called Mr. Smith. I said, when the matter was called up, the trial court noted, said, poor fellow, see how he has been maimed. That didn't go down well with Mr. Smith. Mr. Smith said, yes, the court might as well pass him around among the jury in the box so that they can each touch and feel the injury of the victim. The learned trial judge was furious. He promptly retorted, said, "Mr. Smith, did you just say that? That is a most improper comment." Instantly, Mr. Smith countered, thus, prompted by a most improper suggestion. Not done yet, His Lordship asked this question: "Mr. Smith, did you ever read or hear of Bacon, Lord Francis Bacon, the master of rules, who stated that youth and discretion are ill-wedded companions?" And of course, Mr. Smith was alive to rose up to their feet, and they demanded that the judge should retire to chambers and invite counsel to chambers. In the recess of chambers, admonition was placed where they belong. So I agree with the Supreme Court in the condemnation of the charge by the learned trial judge against counsel in the Metu case. Yes, we all owe a duty of respect to the court, but I think also that the court itself, first of all, owes the duty to respect itself, to ensure that there's no pollution to the spring of justice, and not adopt the position that whatever didn't go down well with the judge amounts to disrespect. So basically, seeing that my time is not much, I leave us with the paper, which is already submitted. Thank you so much. Mr. Chairman, sir, I'm done.
You are leaving us with 2 pages left. Thank you very much. We will read the 2 pages. Because we are on page 114. And your paper ended at 116. This is the Immigration Advocate of Nigeria. Can we please give him a better round of applause?
Thank you, Chairman.
Thank you very much. Now, the floor is going to be thrown open for comments, questions, queries, disagreements, for currencies, whatever. As long as it is done the way we do it in court. Please, if you have a comment, because many people may want to also intervene, we limit ourselves to just 2 minutes. In order to ensure that we enforce the 2 minutes rule, I'll be holding this microphone. So once your 2 minutes is off, you'll be politely interjected and interrupted by the chair. We want as many people as possible to, and I want to appeal to all of us, please, let's leave the songs of praise or songs of praises till another day. JB Dado has done very well by establishing this thing. We've said that, we are tired though. The lead presenter is such a brilliant person. If he's not, he won't be here. So please, let's just, it's just like this thing that reminds me when people are proposing schools, we want to introduce somebody. You know, he went to secondary school and passed. Somebody is a lawyer. If he didn't pass secondary school, he won't be a lawyer. So why are we wasting time? So please, the floor is open. Paul, where is the other microphone? This is my instrument of office. I'm not going to surrender it at this point. So, comments and commentaries from those who are virtually or physically present. Thank you. Please, your name, so that the person who is whom you are going to trouble will know who is the troubler.
Good morning. My name is Chinelo Obozo. My question is to the panel. The new Court of Appeal rules has a provision that I don't know how the panel will react to it. And I want to get the reaction of the panel to that provision. It's Order 6, Rule 11 of the rules. It provides thus: cost shall be awarded against a counsel that allows an incompetent application by an applicant without bringing it to the notice of the court, thereby wasting the time of the court. I want to know how the panel cost shall be awarded against a counsel that allows an incompetent application by an applicant without bringing it to the notice of the court, thereby wasting the time of the court. Now, Order 6 deals with applications before the court. And this sub-rule 11 is saying that any respondent counsel now, who does not bring it to the notice of the court that an application is incompetent, that cost will be awarded against counsel. That is the respondent counsel. Not even the applicant who filed the incompetent application, but the respondent counsel who allows the application without bringing it to the notice of the court.
Okay. Thank you. Divide you. I think this is a question for all the senior lawyers and others here. So that. Yeah. Now, next one. More questions. Okay, please.
Name is Justice Eradiri from Bayelsa State. My question is one, but it will come after the comments of the Leonard Silk at page 57 of his paper. Yes, sir. Yes. I don't know if you permit me to read it. 4.1, the amended law introduced, that is referring to the Lagos State Administration of Criminal Justice Amendment Law. The amended law introduced innovative 4.1. The amended law introduces innovative provisions in the administration of criminal justice in Lagos State, some of which are considered below. Finally, the ignoble practice of the police and other law enforcement agents publicly parading suspects, thereby giving the impression that they are guilty of offenses for which they are to be tried, has been made unlawful and is a misconduct punishable under the extant disciplinary measures of the Nigerian police force. As made unlawful in the Nigerian Police Act 2020, the practice of law enforcement arresting a person in lieu of another is now unlawful, and courts are now empowered upon an application on notice to order the immediate release of such a person if the court finds that the person ought not to have been arrested. Then coming down to 4.2, the last line of 4.2, in further strengthening the constitutional rights of suspects, the amended law provides for suspects to be accorded humane treatment, safeguard suspects from torture, cruel, inhuman, and degrading treatment, and the right not to be arrested in respect of civil wrongs or for breach of contract. Now, my question is this, that all these things we talk about, video recording, suspects, confessional statements, and all that, and even now we are not certain which way to go because of decisions regarding admissibility of statements that were video recorded. Now, wouldn't it be better if the unprofessional practice of police torturing suspects in their police station is also outlawed? Wouldn't that control the situation or at least put a stop to it? Because I'm not aware of this kind of practice in other civilized climes where accused persons or suspects are tortured into making confessional statements? Thank you.
Mr. Chairman, thank you for this opportunity. The number of points, but I will just limit them to two. The first relates to my good friend E.C. Ukalaisi. He raised the point whether proof of evidence is relevant to bail determination. If I can summarize it that way. It's just a way of whichever way it comes out, but my experience in the matter. I was doing a matter in Lagos, and indeed arguing application for bail, Mohammed Bulama against FRN. And one of the authorities, which we rightly referred to, said that in assessing, in determining bail, that the strength or weakness of the prosecution's case is a relevant factor. Now, I knew, remove your hat of LPDC chair on this, that it may pose a likely problem. But I had a duty to avail the judge with all the authorities. Now, the judge, in considering bail, refused to grant bail at that time. Went beyond his brief, I mean in the sense, and said, in respect of this, that he actually found that the prima facie case had been made against the applicant, who is the accused person before him. 3 days after, I returned with an application asking him to recuse himself, because in dealing with that innocuous submission that checked the strength of the case, he actually made a determination that the prima facie case had been made without evidence, without the opportunity of cross-examination. And so he was asked to leave the case, and the case went to the chief judge of the court. The point I'm making here is that it's a very slippery area. You do not know how far to go when you are referring to untested evidence by way of proof of evidence. So my suggestion is that it should actually be discarded as a measure of assessing whether bail should be granted. Do you agree? That is the question. Secondly is whether Dasuki is good law. The matter is before the Supreme Court. The arguments will be properly canvassed there. I argued the appeal, and I will just correct some impressions which my good friend J.S. Okutepa has about the matter. Firstly, there is no issue of a fugitive in the case. The appeal is by Dasuki. He was in incarceration for 5 years in respect of the matter. Had he been charged and convicted for criminal breach of trust, the highest penalty is 5 years imprisonment. And therefore, even if the case goes to court tomorrow, he has served time in breach of his fundamental rights for an offense for which he has not been convicted. So we should always look at these things on a balance. Secondly, the judge acted, Abang J, acted both as prosecutor, as witness, and as judge, importing all sorts of manner of stricture against the appellant in the matter. In his absence, of course, he cannot go for fundamental rights against the High Court judge because there is no procedure for that. He cannot quash the proceedings because it's not an inferior tribunal. And the only option left to him is to appeal. Rightly, there has always been a debate and inconsistent findings on what is the position of the law. However, we asked the Court of Appeal to take a new look at the 1999 Constitution. And the 1999 Constitution makes it clear there are two avenues to get to that point. You can use the avenue of Section 43, which is the one that deals with criminal appeals. It says, just read it because of the interest it has generated. Any right of appeal to the Court of Appeal from the decisions of the Federal High Court or High Court conferred by this Constitution shall be A, exercisable in the case of civil proceedings at the instance of a party thereto, or with the leave of the Federal High Court or the High Court of the Court or High Court or the Court of Appeal at the instance of any person having an interest in the matter. That is for civil cases. And in the case of criminal proceedings at the instance of an accused person, then there is a disjunctive portion, or subject to the provisions of this Constitution. Any powers conferred upon the Attorney General of the Federation or the Attorney General of a state to take over and continue or discontinue the proceedings at the instance of such other authority or person as the case may be prescribed. Now, there is also Section 241, which says an appeal shall be from the decision of Federal High Court or High Court to the Court of Appeal as of right in the following cases. And D says decisions in any civil or criminal proceedings on questions as to whether any of the provisions of Chapter 4 of this Constitution has been, is being, or is likely to be contravened in relation to any person. That is an appeal as of right. In this case, we showed the Court of Appeal that Dasuki's right to fair hearing had been breached. So that his right to fair hearing was in issue before Abba. Automatically, he has a right of appeal without seeking for leave. So we did not seek leave, we appealed as of right. And other JCA looked at all the authorities by both sides, all the authorities that J.S. Okutepa referred to were referred to either by the prosecution in the brief of argument. But he limited consideration of this point to 242. Happily, is before the Supreme Court. Our arguments on 243, which were not considered, will be taken before the Supreme Court. And so, it is not as bad as Okutepa makes it. There was no fugitive offender, and you cannot commend the judge for making strictures behind people at their back. No counsel would like to be made the point of strictures in a matter in which he's not even appearing before, he's appearing before the judge. Talk less of a matter in which he's not appearing. So that's my contribution.
Chairman, I think your term will soon expire, so I can still refer to you as Chairman. But I'm sure the moment I'm done, your term will expire. Don't worry, when the time comes, we will find out. All right. Now, for your questions, first is the troubling issue of Order 6, Rule 11, to which our attention has been drawn by Chinelo Obudo. Yes, it is definitely a troubling issue. Now, I'm not troubled because of the fact that the Court of Appeal is trying to do its best to ensure that they do not deal with incompetent applications. But I'm troubled by the fact that that provision has failed to take into account that some of us are actually incompetent as of right. In other words, you need to know something before you can be blamed for not raising it. So if you are as dull as myself, and therefore you are unable to discover the incompetence in the application, then for that reason alone, you should be punished. I think it is a provision that needs to be further inquired into. Apart from that, our daily experience in the courts of appeal and the Supreme Court sometimes shows that we encounter situations where judges, justices of these courts are sometimes too eager to terminate a case. And as a result of that, they dig deep, seeking for, factors that render either applications or processes before them incompetent, some of which we do not agree with. If a judge, for instance, believes that an application is incompetent because of the fact that the lawyer who signed it did not tick his name, and of course you can find authority for that. If it's of that view, but you as counsel, you are of the view that it is absolutely competent, because the mere fact that you know that this lawyer whose name is represented on the process is somebody who is not only a lawyer, but a well-known lawyer. And for that reason, you do not see the need to waste your time on that. Is that going to be sufficient to have a visitation of cost on you? I think it will be wrong. And then sometimes, as a practicing lawyer, you also want to reserve certain issues to be raised at a time where they will have proper impact. If, for instance, it turns out that your application is going to only aid the other party to go and make an amendment and come back, whereas there are more serious issues in the appeal which could have been determined along with the issue of competence, is it wrong for you to lie in wait? I do not think so. I think that this is not a very practical provision. So that is my response to that. Now, on the point raised by Justice Radiri, yes, the issue of torture by the police has already, long time ago, been outlawed. The police are not really different from any other member of the society. It just turns out that we hardly ever enforce these provisions. Now, if a person is being tortured by the police, nothing stops his counsel from taking out proceedings for the enforcement of his fundamental rights. Nothing also stops counsel from making complaints to the police authorities to say, charge him for this kind of misconduct. All these things have been there. In fact, most of the provisions that we find in the Act of Lagos have actually been there, but are only being re-emphasized so that it is brought to the fore. It's like nowadays, people demanding that it should be included in the Constitution, that after a man has been president, a woman should come next. That type of thing. It's not everything that can be written into a statute or into a law. If our courts are doing their job as they should, some of these are things that can be enforced. I am, for one, I've always said that even our Constitution as it is, as imperfect as it is, we can walk through federalism out of it, depending on what the courts are ready to do. But we have a situation where courts are more executive than the executive. You bring an action before a court of law, and the judge is telling you, hey, if we take this decision, where is my salary going to come from? As a matter of fact, I was asked that question in the VAT case. The judge said, where do you expect my salary to come from? If I say that the federal government, which is reaping so much from value-added tax, does not have the powers to impose value-added tax. He was a courageous judge that at the end of the day, he was still able to come to terms with the law. Otherwise, that was enough for him, that this is what we should consider. So most of the time, what we are looking for, what we want to be written into the law is already there, available through interpretation. If you look at the Constitution of the United States of America, you find that it's just a tiny pamphlet. Anything happens, somebody says, First Amendment, Fifth Amendment, and that's all. And that carries a load. And which is that load? It is interpretation that has been given to it over the years by their courts. If our courts are ready to do their duty, and the lawyers are prepared, are sufficiently versed to guide the courts in doing their duty, I don't think we need to write and rewrite all these things into our law. So, Justice Aradiri, that is my position in respect of your question. Thank you. Now, JB Daudu, SAN. Proof of evidence with regards to bail application. I'm sorry. I do disagree with you on a number of occasions. On this occasion again, I disagree with you. Now, the simple reason is this. Without the proof of evidence, it is impossible for the court to know the strength of the case of the prosecution. Now, that strength is not usually considered against making a finding as to whether there is a prima facie case or there is no prima facie case, which unfortunately some judges drag themselves into. So that is just an issue of inexperience. It is an inexperienced judge who drags himself into that area. But otherwise, it is a question of determining the strength. Is there enough strength in the case of the prosecution for me, in good conscience, to keep this person behind bars until the trial is over? In a case, for instance, where all the statements that are contained in the proof of evidence do not mention the name of the person that is the defendant before the court. Why should such a person be kept behind bars until after 3-4 years of trial? That is where the issue of proof of evidence comes in. It is definitely not there for the purpose of making a finding whether there is a prima facie case or there is no prima facie case. It is not at that stage that a judge who knows what he's doing should engage in that kind of enterprise. Now, with regards to Dasuki's case, I agree with you to a large extent. And I disagree with my brother Silk, Chief Okutekba, SAN. Or is it Prince? I'm sorry, whichever. Some people who are princes don't like to answer chief. So, but the point is this, that whether it is even there, expressly provided for in the Constitution or not, it does not make sense for a person who is not standing trial before a court of law to be found, in quote, guilty of a criminal offense for which he has not been given the opportunity to face trial. Way back, I think that was it 83? I can't remember the title of the case, but I think it involves Obasanjo. It is one of these election petition matters. What happened in that case was that the election petition had a number of paragraphs dealing with what constituted criminal offenses that were committed by electoral personnel. But those personnel were not joined as parties to the petition. And the court said, look, you cannot try a person behind his back. And the practice has therefore now developed, especially in election matters, where all those paragraphs are struck out. If after striking out all those paragraphs, making reference to persons who are not parties, but who are alleged to have conducted themselves in a manner that constitutes offenses against the Electoral Act, once those paragraphs are struck out, if there is still anything left to enable the petition to continue, it is only then that the petition continues. So if a judge is alert, in a case where a lot of issues are hanging on a person not before you, it is only proper to direct that the person who they are referring to should either be charged or you cannot proceed with the matter until that person is charged. Otherwise, all those allegations against that person or that will involve that person should be struck out. If after striking them out, there is still anything to be looked into, then of course you can proceed. If there is nothing else, you forget about it. I am in agreement that Section 241 is sufficient for the purpose of making an appeal in respect of such matters, and that was what was utilized. Definitely not Section 243, because Section 243 mainly relates to civil matters, and then in addition to that, it is also talking of leave, which is not necessary. I do not know whether I have covered the areas. If I have, I thank you very much.
Go the way of Dasuki. I want to say that, speaking for myself, I've gained quite a lot coming here this morning. The lead speakers and the discussants, they have shown more than enough evidence that they were up to the task of coming here to share knowledge. And for sharing their knowledge without hoarding, can we please give all of them a standing ovation if you don't mind? Thank you very much. Thank you, please. Let's take our seats. There are two things you gain by this. Number one, we are showing appreciation for those who have given us food for thought But importantly, we are obeying a medical rule that after sitting down for some time, it's better to exercise your feet and your body. So, can you please clap for Dr. Yusuf Ali for giving you this free of charge? Thank you. Now, I have a suggestion to the foundation. You have caught a niche for yourself in this area of practice and discussions. May I suggest, Paul, listen. May I suggest, and I know you have quite a number of all the lawyers in this office, fantastic researchers. May I suggest for the future, so that there will be no too much overlay or repetition, when we identify matters of this nature, for example, the topic we have been dealing with, for example, all the cases in this area are well known because they are recent decisions. The same with the legislation. When we are having more than one presenter, for example, lead presenter, for example, can we not then share the cases and the legislation between them so that we would obviate repetition? Because this Identification wasn't online when Bukalaisen was doing his presentation. He didn't have the benefit of all the cases which he also had to repeat. I think for the future, that's my humble suggestion that I think should. Now, before I forget, this is a newsletter produced by the Rule of Law Development Foundation. This is the maiden edition, if I'm not mistaken. Sir? Oh, second one. So, copies will be given to all of us at no cost. But I've browsed through when it was given to me, and I think it's going to be a treasure of knowledge for those who can go through, especially the interview for the founder, which you'll find in about 3 pages of this. I've been given sufficient copies. Don't think I'm going to hoard them. I won't. I don't know. You don't need that, do you? Okay, take one and pass round as going forward. So I think that would be the easiest way of distribution. Now, let me lend my voice to the listen to your order 6 Rule 11. I think it's complementary of what Bukala Essien said about that order. It may look a bit draconian, but I think the Court of Appeal, and I'm happy, all of us there that are lawyers, we go to court every day, or as often as we do. When a frivolous application is filed, I think that rule is just to put counsel on notice that we should be diligent, actually. I think it's a call for diligence and vigilance by lawyers. Somebody files an application that's supposed to be a Trinity prayer. It brings only 2 reliefs. Apparently, it's incompetent. So we must all pay attention to the work that we do, and I think that's just the whole essence. It's a way of giving us a shot in the arm that we should. I agree with Bukala Essien, even though JB never said so much, but I also agree. You see, and with due deference to our judges, Nigeria has a crop of very bright individuals who sit in judgment from the lowest court to the highest court of our country. One thing that I think that is not in sufficient quantity is what I call judicial valor. I don't want to say we have judicial cowardice. That's negative. I think what we need is judicial valor. Nigerian judiciary is one of the freest you will find in any commonwealth, in any system. But if you decide to put chains in your own hands, what can you do now? And the good thing about it is that to remove a judge is a very daunting task in this country. Very, very. But it's for their lordships to just know that when they do that which is right and proper, they have the voice of the profession behind them and the people. We are getting to very dangerous levels. When EFCC invaded the houses of the justices in those days, it was just to cow the judiciary, nothing more. It was not with any altruistic reason. I've said it openly everywhere in interviews. And the current exercise in futility in Justice Odili's house is in the same frame. It's for their lordships to stand firm. Fascism creeps in when good men goes back on their moral Bibles. We must all be alert. Who will pay my salary? We are in a system. This Kabi syndrome, which was unfortunately promoted, anointed by the former Chief Judge of Lagos State, I won't mention him, may God rest his soul. He shouldn't have a place. This is a society of law, not of men. We are ruled by law, not by men. So, and I think we should all just know. And this challenge also goes to we that are counsel, that are lawyers. We should not encourage their lordships to take decisions that we will not be proud of. Because all said and done, there will be lawyers on either side. We should allow our judges to flourish and come out with their best. And for those of us who have never read Justice Kayode book, The Clinical Government, The Unknown Gunman, can we please go and read that? You will see that those who will, like I always tell people, something you can never acquire later in life is honesty. If you are not honest from the beginning, you can't acquire honesty later in life. It's the same thing with courage. If you are lily-livered from beginning, it's likely you are going to end up that way too, going back to the Creator. But if you read that book, Justice Kayode, when he was assigned, for those of us who are holding enough, I'm talking in reverse order. You recall that in 1964 or thereabout, a government, the then premier of Western Region, Sir Ladoke Akintola, he recorded a message, a speech he was going to transmit on WNDS, Western Nigerian Broadcasting Service. At the point of, because there was no live something in those days, it was pre-recorded. So the cassette was brought to the radio house. As it was about to be played, a masked gunman came in, took a gun and said, and then took the cassette and took it away. Now, during the time of investigation by police, they zeroed in on the Nobel laureate, Professor Wole Soyinka, that it was the unknown gunman who came to the studio with a gun to take the tape. So he was arraigned in the court. At that time, Justice Kayode was the most junior judge of the High Court of Western Region. And the case was assigned to him. The man, there was Opola, there was Labalu in the newspapers, in the radios. It was Soyinka. They knew because the man had bushy hair. The man who came with the gun, even though he could use a mask, they could see his beard. In spite of all those, what I call rumors of the construction sites, Justice Kayode dealt with the facts and the law, and discharged and acquitted Wole Soyinka against all the expectations of the normal, ordinary people. And he said, the heavens will never fall. Yeah, of course. At the time, the premier invited him and others to the government house in the course of the trial. The premier could not talk to him directly, sent one of the ministers. And the man said, if you read the book, the man said, he now saw the premier, when the man was shaking, I said, Mr. Premier, I learned you wanted to say, Oluwa mi, who am I? To say I want to see a high court judge. I bow, sir. Of course, SLD himself was a lawyer. That was the end of that matter. He gave that judgment and he still rose in the system to be one of the very best justices Supreme Court of Nigeria ever produced. So once you are upright and you are okay, you don't have any problems. So I want to appeal that we should not just listen to these lectures and something and go away. It should be a lesson for those of us who are lawyers and who are judges that we should do our duty as long as our consciences are clear. Nothing evil will come to us. On a final note, I want to thank the Rule of Law Development Foundation for instituting this series of enlightening discourse. There is a question here. Paul, sneak this in here. Let me read it. By David Begge, Stephen. Good day, learned silks, presenter, panelists, and colleagues. My question is as follows. I'm reading him verbatim at literalem. Taking into consideration the provision of section 34(1) dealing with prohibition from cruel treatment and section 36 dealing with fair hearing of the Constitution of the Federal Republic of Nigeria 1999 as amended, and also precedents from the Supreme Court of India and the United States, is it possible to argue within the Nigerian judicial context that, quote, prolonged delay in the execution of death penalty on a prisoner on death row, end of quote, can stand as an appellable defense against the execution of the death sentence and the charging of that, the changing of that sentence to life imprisonment? I think there is a case done by Agbakoba. So go and read. That's why, colleagues, God bless you. Some of us are, this thing is moving now. Don't worry. No, don't follow us so that fast, so you'll be remembering this. So, since you are online, please go and read that authority. Where Agbakoba took this matter on about 10-15 years ago to the Supreme Court, and you see the answer. Yes, of course, on the point. Yes, so please, that's why we encourage our colleagues, read widely, read extensively, so that you enrich your mind, enrich yourselves. Thank you very much once again. I think this session is declared closed by the powers conferred on me. And I resolved the out by myself. Okay, thank you.
Let us give the panel a resounding round of applause. We want to appreciate you, Mr. Chairman, for steering us right on time. I think we were to finish the session at 12:45, and it's 12:30. That's 12:13. 12:13. So you can see we have a bit more time until the next session. Unfortunately for us, the tea break is not exactly ready. So, so at this stage, I want to deeply, on behalf of the Rule of Law Development Foundation, appreciate the chairman, the lead presenters, and all the resource persons for taking us through this very important aspect of our criminal law, which involves the practice and procedure. Particularly Mr. Denwuge, who joined us online. Sir, we are very grateful for you taking out time, and you have stayed with us throughout.
Thank you.
It's just that this year, normally, sir, you give us proverbs, and we noticed that those proverbs were not there this year. Especially the ones you say your father used to tell you.
Thank you.
So hopefully next time we look forward to more of such proverbs. I also want to thank the audience and everyone for staying to this time. If you look at your program, the next session is taking place at 12:45. So we have a bit of time to take pictures, network, and immediately we will start at 12:45. Most of our resource persons are here. What are we talking about next? We are talking about the unlawful criminalization of freedom of expression. A lot of things have happened within the calendar year, particularly the NSAS protest and other issues and other legislation which a lot of people feel are impacting on our rights to freedom of speech. And we will be joined by Chinoye Obiago, Senior Advocate of Nigeria. Chinolo, I don't know if he's around. I thought I saw him. Okay, he's on his way. Then we have Ebunoluwa De Burua, SAN. Then we have Nureni Jumo, SAN. We have the police this year being represented because I really want to hear from the police. Because, and it's represented by their SAN designates this year, Love Simon Asemba. And we also have a human rights activist in the form of DG Adeonju. DG is already here. DG, you're welcome. And we look forward to hearing from all of you on this very, very important topic. So at this stage, the session can close, and please let us all be back by 12:45. Thank you.
Is that the boy child is exposed to negative thoughts and vices in the community. This situation is compounded by dominance of poverty and ignorance, which make the boy child susceptible to negative peer influence and indulgences.
Girls are at risk, and sexual and gender based is on the rise in the communities, and most times perpetrators are actually boys, the boy child. So that's why one of the reasons why this project is here.
In the community, the boy is exposed to a high level of sexual abuse, rape, and gender-based violence, especially driven by abuse of dangerous substances. Such a boy child develops into an easy and pliable instrument in the hands of self-centered politicians who put him to use in electoral violence.
When people are not, or the rural populace is not guaranteed right to free education and right to also participate in political activities and governance, we must then come in and play a role. Now, one of the best ways to do this also, again, is to catch them.
Please, photographers, let us have a group photograph with all the resource persons. And our distinguished guests, please join in the group photograph.
Very worried when something happens to the fairer sex. I don't refer to them as the weaker sex, because in most cases,
let's arrange for group photograph.
Women are.
Dr. Lion, please join. My lord, please join.
The boy child who is trapped in that situation turns round to detest school, and the consequence is that he will become prevalent in the absence of mentorship and counseling. Even while in school, albeit reluctantly, the boy child indulges in cultism, theft, and other petty crimes. Again, this is another consequence of peer influence. Apart from diminishing the boy child's potential transition to adulthood, he falls off the path that leads to future leadership positions. Instead of being a beneficiary of the alluring dividends of the socio-economic and political life, he degenerates into the class of wasted generations.
Where do men get this idea of violence towards women, toward things like rape, and early disengagement of the girl child from her educational pursuits? So we find that you can trace these things to the activities of men, maybe older men, but before they get to that point, there must be a frame of mind There must be a state of mind that influences that. So what we did was to say, well, if you can arrest this untoward development at a point, start by re-educating the boy child, start by ensuring that he places a different value or a higher value or premium on the girl child. It will get to a point where if you saturate the system properly, you will find that the boy child is no longer a danger to the girl child and is no longer a danger to himself.
The situation has become very precarious in the Federal Capital Territory, and it is created by the insurgency, particularly in parts of the northwest and northeast of Nigeria. There is an exodus of young boys fleeing from the theater of insurgents and have found the Federal Capital Territory as a safe haven. There is therefore unjustified and frightening pressure, particularly in the suburb of the FCT. The migrating boys roam the streets and the blind alleys, engaging in untoward activities, and some of them constitute nuisance values. They are easily exposed to vices and risky options, which put paid to the choice of schooling or even engaging in decent means of living.
In the rural areas, there is less economic empowerment. Parents, the burden is placed on parents alone. And it gets to the point whereby without any aid or assistance to them, they bear the brunt of their being in the rural areas more than those in the urban areas. Secondly, it is always better to take a bottoms-up approach. And thirdly, there is the issue of funding. If there are limited funds, it's best to apply it to areas that are very apparently marginalized and deprived. Right now, the funding is being done exclusively and solely by the Rule of Law Development Foundation, which gets its own funding from what we do in the legal profession. So it is from the chambers of J.B. Dowden and Co. Whatever comes to the principal partner, that is what he invests in this. So it is like a corporate social responsibility. If people come in to ask us for cooperation and the blueprint for this, we'll be glad to share it because it's something that helps and assists humanity.
When the choices are available, some of them take up hawking, even with the risk associated with it. There is the urgent need to reverse this dangerous trend, and that is what Project Hope for the Boy Child is conceptualized to address. ROLDF started to work on the pilot of Project Hope for the Boy Child in April 2021. The project is an inspiration. It is a deep understanding of the sociological context, the environment, and the psychosocial background which shape and mold the boy child. The ROLDF understands this very clearly. The organization understands that the boy child who is a victim of such denial and abandonment is emotionally unstable, and the communal discipline means nothing to him. What then is Project Hope for the Boy Child? Project Hope for the Boy Child, PHFBC, the brainchild of the ROLDF, is a comprehensive, age-appropriate, rights-based, youth-friendly, and gender-approach intervention that guarantees the safety, well-being, and economic future of young boys as major perpetrators of most acts of violence.
Project Hope for the Boy Child, as the name implies, is a project or an intervention targeted at the boy child to help them, because the boys have actually been left behind. out of a lot of interventions from civil societies and from organizations, agencies, and donors. Why? Because girls are seen as more vulnerable in the society.
In conceptualizing the program, we try to think of, because every time you talk about the girl child, there are a lot of activities. And so we look at the boy child who returns from school from age 9. Our catchment group is from age 9 to 17. And they return from school and they go and play football and look for other things to do. And it is said that the idle mind is the devil's workshop. Now, if the idle mind is the devil's workshop, then there is a need to keep them busy and occupied. Busy and occupied, so we said, look, why don't we think of looking at the deepest rural areas and then find vocations for them so that they can learn professions.
The project is building capacity of young boys for economic stability through skills acquisition, while also providing a reorientation through facilitated discussions on broad topics such as human rights, toxic masculinity, sexual and gender-based violence awareness and prevention, harmful practices, financial literacy, decision-making and consequences, as well as peace and nation building. The Children Act 38 of 2005 states in its preamble, and I quote, "It is necessary to effect changes to existing laws relating to children in order to afford them the necessary protection and assistance so that they can fully assume their responsibilities within the community, as well as that the child, for the full and harmonized development of his or her personality, growing up in a family environment and in an atmosphere of happiness, love, and understanding." Essentially, the new Children's Act seeks to fundamentally transform the nature and provision of services to children, to protect them from harm caused by exploitation, neglect, and abuse, as well as to promote the right to survive, to be safe, to belong, and develop. With regards to the boy child, the aims translate to the creation of an enabling environment, prevention of abuse and neglect, reduction of risky behavior in young boys and school dropouts. It also translates to the strengthening and development of community structures and resources that can help in providing care for them. These goals, according to facilitators of the project's Hope for the Boy Child, are realistic through deliberate effort at empowerment of the boy child. At the pilot stage, ROLDF targets 100 boy children aged between 10 and 16 years from poor select communities from the Abuja Municipal Area Council in the Federal Capital Territory, FCT. The communities are Waru, Kabusa, Kurudu, Kuchingoro, and Karo Majiji. Vocational centers are being built in each of the 5 select communities. The ROLDF says the aim is to assist the boys acquire and develop economic and life skills that can help in improving their living standards, keep them safe, and away from social vices.
We decided that since boys can be very active and you need to be engaged, so we decided to get out of school, boys who go to school after school hours to attend these sessions, and we provided them with economic skills. We ensured that we got artisans who are resident within the community for safety purposes, and they learn for about 2.5 hours and they go home. Of course, during the holidays it's longer. They can be there from morning till evening learning these skills because it's a limited period of 6 months for them to learn. Yes, so you go on social media now and there's a rape posts, you see boys, young men, making fun and cracking cruel jokes under rape posts. So this to tell you the mentality, and this is what we are trying to change through the mentorship. So we are also addressing some other topics like drug abuse and substance abuse and addiction, creating awareness because it becomes a mental illness once they cannot handle it. One of our communities in Kuchingoro, I met a father who was telling us this project is dear to his heart because his own son was killed, his first son, in 2017. He was stabbed to death. over a little argument with another young boy. And his son is gone. The other boy too had to live his life because after that he still killed 2 other people, one in Zuba, one in Kano. They had to trace him and he was sentenced to death by hanging. So now imagine if that boy was actually opportune to have conversations with his parents or even mentors around him who can tell him the consequences of the behavior, choosing good friends, then he will be better, and I don't think he will be dead today. 2 boys will have been saved.
The Rule of Law Development Foundation is a non-governmental organization, civil society, conceptualized and created so as to intervene in matters of rule of law, due process, human rights, and good governance in Nigeria. So wherever the organization sees breaches of the principles of the rule of law, it intervenes, and it intervenes in a number of ways. It does this by education, by publicity. It does this by intervening, by going into the issues themselves. It does also this by public interest litigation. We collaborate with other NGOs because we cannot do everything. And where we find ideas that are similar to our own objectives, we partner with them and indeed try and see how we can make a difference in it.
Promoters of Project Hope for the Boy Child believe that while it is important to reach young people with information on life skills, it is also very crucial that they are exposed to mentorship sessions alongside their peers.
The mentorship aspect that comes up every 2 weeks in the communities, for the 5 communities, for the 100 boys, we have a facilitated conversation on decision making and consequences, human rights, sexual and gender-based violence, and the various forms it occurs, and the roles boys have to play. In our survey form or the pre-test form, like a questionnaire we took before to test the boys' knowledge of this subject before we started in the project, we had questions like, can a boy child work with girls? A lot of them said no. So there's this gender bias there. We also asked them questions. Is there a difference between control and defending? And they said there's no difference. So these are the issues we'll be addressing. We're talking about toxic masculinity also. Then we'll be changing gender orientation. When I say gender orientation now, the ideas of what a boy child should be or how a boy child should act, we'll be telling them how to do it better. We're talking about values, kindness, and the role of boys in society, because these boys later become fathers also. So when they understand human rights, when they respect human rights, they can do better when they become older adults.
The mentoring program is designed to attract and appeal to the young boys to respond to their needs and increase the likelihood of their interest in a purpose-driven life after being armed with decision-making skills. Some of the skills available to the boys for 6 months are aluminium and glass work, tailoring, barbing, upholstery and furniture making, mechanic, mobile phone, electronic repair, bicycle repair, computer literacy, and cobbling, fondly called shoemaking in local parlance. ROLDF is leveraging on seasoned skilled people to train the boys at the vocational centers situated in each of the 5 poor communities after their school hours on a daily basis. According to ROLDF, the trainers for the identified life skill topics are expected to visit twice in a month during the weekends to provide age-appropriate information to the boys.
We have to first of all know that they are willing to do this. And what I found out in him is that he really wants to do what he's doing. He loves doing it. He loves preparing. So we'll try to score them stage by stage. Theoric, then practical. See, there's a very big change because even the parents also give this testimony.
The Rule of Law Development Foundation, they brought Project Hope for the Boy Child. That made me to learn more about this that I'm doing right now. When I just close from school, I just come here to learn more about the carpentry work. I've learned about to save money, make small things to have money, and during the mentorship, they have taught us a lot about human rights, that where my rights stop is there that another person's rights continues.
Since the project Hope for the Boy Child came in, I have now learned how to sew shirts, trousers, and so on and so on. They teach us boundaries, how to set boundaries, set goals, and how to follow good friends. Before I know them, I do follow bad friends that makes me to carry my mommy's rice and go to the bush to cook. But since I know them, I have stopped such. I have an uncle that usually send me to go and play bets for him. But now if I see him, I do run, never to go to the shop again. Now I'm now focusing in my tailoring and now learning how to make my own money to be a good person in life.
I'm learning barbing work. So the first day I started learning, I can't even hold clipper. So the first day I even hold clipper, the thing fell down my hand. But now I can even hold clipper and barb any hairstyle. After school, this is where I come. So when I come, I learn how to barb. Now I'm perfect. The money I used to have, I used to save it, and I used to set goals, and after setting, and I achieve them.
For the project they have been in part, we have like carpentry, tailoring, and then glass work, and also we even have a mechanical engineer for the bicycle repair. So I'm saying that they have been on it for a long time, and they are still on it up to now. So for the also theory parties of teaching them how to not to be violent, and also human rights, to know their right of movement and some other things, for them not to be as any other children in the community.
I'm one of the beneficiary of the project for the Boy Child. They came here a few months ago and chose me to be one of the people to empower, and I'm very, very happy. I've learned a lot. In the tutoring, they taught me about decision making and its consequences. They taught me human rights and how to respect people. They taught me the kind of friends to make, and since then I have separated my good friends from the bad. They taught us that drug abuse is not only when you use drug too much, even less than the doctor's prescription or without the doctor's prescription, that is drug abuse also. We've been taught sexual and gender-based violence. Now I know how to respect my sister and all my female friends. I learned that beating a woman is not right at all. I want to thank the Rule of Law Development Foundation for giving me this opportunity, for tutoring me on how to become a better person in life. And now I know my next step in life as a boy child.
I started when I was small. I love making hair, especially my grandmother's hair. That was how I got the interest of making hair. I used to tell my brother, my senior brother, to put me in handwork, so that I will further my hairdressing. So when I heard about this project, I feel happy. 3 months ago, I started this work. Like, I've done perfect work. So many work I've done. I'm so happy for it. I want to thank Rule of Law Development Foundation for organizing Project Hope for Boys Child.
The pilot phase of the project in the communities in FCT is designed to achieve the following objectives. 1. To equip 100 boys in 5 communities with economic skills in 6 months. 2. To promote safety and reduce vices by young male perpetrators in 5 communities. 3. To build the capacity for positive decision making and increase the quality of their lives. 4. To reduce poverty in 5 communities. 5. To promote peace and nation building in 5 communities in FCT. And 6. To have 100 young boys as ambassadors for the prevention of SGBV in the 5 select communities. The project is crested on the conviction that the boy child is not just a formidable demographic force, but also makes up the next generation of parents, labor force and leaders whose well-being has ramifications for their lives and for the societies they will build and maintain. The project's hope for the boy child team